suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
Indeed, it is that time of the week when we are joined by Melbourne solicitor David Whiting. David Whiting, good morning and Happy New Year.
Happy New Year to you, Ali.
Well, if you've got a question for David, 1300 222 774. And David, I just want to actually just talk about something completely, you might have a thought about this, but just prior to the news there, I took a call where someone was talking about how our politicians don't have to be vaccinated. And indeed, in Victoria they do, but I was unclear on the situation, so I've done a bit of research and I probably should have known this, but federally, there is no vaccine mandate for federal politicians. I was surprised by that. Does that surprise you, David Whiting?
No. There's in fact protection provided to politicians who want to get to Parliament. That you're not supposed to hinder someone who's attending a parliamentary event, like a sitting in Parliament. So no, that doesn't surprise me in the slightest. But you will note that if there were politicians entering the ACT in order to attend Parliament, they had to comply with ACT rules, didn't they? I thought.
Right. Okay. So there are ways around it to a certain extent.
Yes,
but
you may not come and visit the ACT unless you've been properly vaccinated.
Well, there you go. So before we get to calls, again, 1300 222 774, have you read the documents of the Djokovic case?
I have. One might say I have consumed it. I haven't read the judgment, but I've been reading all of the material and just wow. But, if all you need to do is watch Border Force on television, and that's the way they do it. Yep.
Yeah, maybe. I don't know about your take, but we've had different views this morning about what the case was actually a judgment on. But my understanding is that the decision to overturn the visa cancellation was based on whether or not the process was fair, not about whether the exemption was valid.
We're entitled to what the law calls procedural fairness. And on my reading of the material at 5:20 last Thursday morning, Djokovic was told, you have until 8:30 to give us reasons why we should not cancel your visa. Now, at the airport, there are officials appointed by the federal government who have the right to, arbitrarily and capriciously or with cause, to cancel somebody's visa. But they're required in every instance to give procedural fairness to the person whose visa is subject to cancellation. Now, at 5:20, they said, you've got till 8:30, and then give him till 8:30. They'd already made the decision to cancel the visa at 7:45.
And if it was...
And that's just that simple.
Yeah, it is, isn't it? So it's not about the validity of the exemption. It's and in fact, I'm just reading, I don't know if you've got a spare 10, 15 minutes, you can read the transcripts of the interviews. But, Djokovic says it would be almost entertaining if it wasn't quite so serious. But he says, so you're giving me legally 20 minutes to try to provide additional information that I don't have at 4 o'clock in the morning. You kind of put me in a very awkward position at 4 in the morning. I can't call the director of Tennis Australia. Well, he can't really, can he?
Well, you've got to know his number first, don't you?
But even if you've got his mobile, I don't know, calling him at 4 will... Anyway, it is... Yep. Right, so yes, an issue of procedural fairness. Very good.
Now, and in theory, so where that takes you back to is the cancellation disappears, the visa remains in force or is reinstated, if you like, but it's still subject to the right of cancellation. It's subject to the right of cancellation by cause, by the Immigration Department, and it's subject to cancellation without giving a reason by the Minister.
So how long does that right remain there? At what point?
Till Mr. Djokovic leaves.
Is that right? So yes. The fact that...
So in theory, it could be between the semi-final and the final. I'm not saying it would be. I don't know anyone's that silly, but as a matter of theory...
that'd put a cat amongst the pigeons, wouldn't it?
Oh, wouldn't it ever? Yes.
Gosh.
But the Serbian rules aren't that different from ours.
They also have a right always for refusal at the border.
and not only refusal at the border, revoke at any point.
Does every country have that?
Yes. I'm now declaring you to be we have this beautiful phrase called an unlawful non-citizen. Now, a long time ago, we used to call them illegals, but, that's pejorative language. So we now refer to them as unlawful non-citizens, people who have no rights that we choose not to give them.
So does we're all sort of waiting and all the headlines are that the immigration minister is reserving his right and
Yes.
we're all waiting for some sort of announcement. But is it perfectly plausible that no announcement will be forthcoming and they just may or may not between now and whenever Djokovic is out of the tournament or wins it?
Do you remember a Tamil family from Billawilla in Queensland?
Indeed.
All waiting and still waiting, I believe, on the exercise of a ministerial discretion. Now, what's that, 3 years? So why do we think that the Minister for Immigration will do anything other than exactly what the Minister wants to do at the Minister's timing?
Interesting. Yes, David, thank you. That's put a great deal of clarity on the situation for us. Thank you. Okay, let's get to some of our callers at 1300 222 774, or you can text, but we'd rather you call and have a chat to David. But if you would like to text, 0437 774 774. Jenny's joined us from Malvern. Hi, Jenny.
Hi. Our son is about to settle on a strata property that he's just bought. We've measured it, and in the front yard there's an area 4 metres by about 60 centimetres where the fence has been built inside the property line on his title. He's about to settle in a couple of days. He's raised it with his conveyancer. They've said you can't get out of it. He doesn't want to get out of it. He still wants to buy the property, but just wondering what he should do longer term about this piece of land.
Can you tell me, Jenny, is it between his unit and the neighbour's property or his unit and the common property?
His unit and the neighbouring strata property. So he's buying unit 2. The fence is 60 centimetres into the front yard of property 1.
Okay.
The property was subdivided. Strata was approved at the end of 2007 and all the surveys were taken place in 2006. So it was signed off in 2007. So it's...
Yeah, well, then the answer is he can have the land back.
Yeah.
And I say that because rights of adverse possession arise at 15 years.
So even
now,
though...
the end of 2007 is the end of 2022.
Yeah.
Right, so it doesn't matter when the survey was taken.
Yep.
It was it's even later than that. The question is, what's the day upon which units 2 and 3 ceased to be in common ownership?
So would that be the date the plan was registered?
No, it would be after that.
Okay.
I mean, in theory, it could be that day, but
Yep.
as a matter of logic, the developer enters into a contract to sell the land.
Yep.
Normally, these days, you do settlement 14 days after after notification of plan registration. So it would be after that. So based on the Limitation of Actions Act, the date of registration of the plan, you would need to actually work out when the 2 lots were sold.
Yep.
And it's when the first one is sold and they cease to be in common ownership.
Yep.
That's the earliest possible date at which rights of adverse possession could have arisen in favour of the neighbour. So yes, your son can have his fence back.
Okay. What's the procedure for doing that?
It's you would probably, if I was going to run an adverse possession fight or a fight to regain possession,
Yep.
I would be getting a formal survey,
Yep.
not without knowing your son or his deafness with a tape measure. I would be getting a formal survey to re-establish the correct boundary line, and I would then be talking to the owner next door and say, this thing's 2 feet out.
Okay.
And in the event that doesn't achieve the right, then you go off to court and you spend more thousands of dollars moving the fence.
Jenny,
Right.
Good luck to your son with his new property. There are a couple of lines left, I should say. So if you're waiting to talk to David, jump on now. 1300 222 774. Claire in Coburg. Hi, Claire.
Hi, Ellie. Hi, David.
Please.
I just wanted to find out if you believe that a power of attorney, whose role it is to act on behalf of a disabled person, is incapable of filling their role, what can you do?
You technically make an application to VCAT for revocation of the power.
Okay, application
So
to
VCAT has, under the Guardianship and Administration Act and under the Powers of Attorney Act, the ability to revoke a power of attorney that is not being properly managed.
Okay. Do you know...
Right now, all I
sorry,
can tell you is that there are delays at VCAT which are shuddering. All right?
Oh, okay.
It is not a fast process.
No, it's about 2 years behind, isn't it, right now?
Well, that's for general cases. I'm involved in one at the moment where it's an application for guardianship made in respect of a person with a disability, and that application was lodged in September and we haven't had a hearing yet. So the guy's still in hospital because he can't be released till the issue gets resolved.
Wow. So not even a priority process?
No, there is a priority process, but we're not far. Because he's being well looked after in hospital at the moment, the next decision can't be made.
Okay.
Right, so yes, it's a priority, but while he's safe and secure, it's less of a priority than if he wasn't.
Very good, Claire. Thank you. Julie in Northcote. Good morning, Julie.
Good morning. Thank you, Ellie and David. It's regarding a fencing dispute. It's been going on for 3 calendar years, but it's actually only about 16 months.
Yep.
Okay, so the neighbours have agreed that the fence needs doing, but they're sort of stalling because they're going to sell the property. And so what I'm asking is, regarding the vendor's statement, I understand the fencing dispute, the fencing notice goes in the vendor's statement. What I'm trying to work out is how long that, I know about the 30 days, etc., but with a vendor's statement, how long is the fencing dispute legal for in the vendor's statement?
Are you putting it in your statement or you want them to put it in their statement?
Oh, thank you. I want to put it in theirs, and they're aware that I want to do that.
Have you given them a fencing notice?
Yes.
Right. What I would be doing is that I would bring... The fencing notice is essentially no more than, I want a fence, and if you don't do something, I will force an outcome.
Yes.
Right, by going to court and issuing a fencing summons.
Yes.
So it's no more than perhaps like a letter of demand, I want the fence fixed.
Yes.
So from your point of view, if you wanted to move it along, I would probably go and issue the fencing summons. Right. Now, so there's 2 parts to this, Julie. The first part is you and the neighbour.
Yeah.
And yes, we need a new fence, but I'm going to stretch this out as long as I can so I don't have to pay for it. Right? So you trigger that by bringing the fencing summons, and at that stage then you'll have an argument that you're entitled to the cost of the whatever works are required, even if your neighbour sells. All right? Now look at it from the point of view of the person who's coming along and buying the property. He's looking, or he or she are looking at buying a property with a very ordinary fence, one that is in. So it's kind of a really mixed question as to what the end result will be. But in terms of you and your need for a fence and your desire that the current owner contributes to it, then you would issue a summons under the Fencing Act. You would not rely on the fencing notice.
Okay.
Right?
It's complicated by the fact that...
It's your brother-in-law, is it?
No. It's complicated by the fact that it's actually not based on money, I don't think. They do have a rather lovely garden, and you can't see how horrible the fence is from their side, and their foliage pushing all over to ours. But
yes.
But none of that should make a difference, David, should it?
No, none at all.
They're a little bit smarter than I, in the sense that they've sort of told me that in court that because the fence is not totally falling over, that it would be found that that they don't have to change the fence. But even
if the fence is only being held up by their shrubbery, I would have thought your chances would be excellent. Yep.
Julie, good on you. Gosh, there's a lot of fencing calls this morning. Not quite sure why. Shiv and Geelong.
Because people have had a month to look at them. Yep.
Maybe that's it. Hi, Shiv. Have you been staring at your fence for a month?
Yes, I got a fencing issue as well, actually.
Yes, exactly.
So what happened, I'm just building a property, but it's been done. We are moving this week or maybe next week. And then it just regard my rear fence. I got the details from the Geelong Council about my neighbours, and I sent them a couple of letters now. One was a registered post, and they all came back. So because this neighbour is not far away where I'm living now, so I went to the door, I knocked on the door, and the people who lived there, they said they already moved out in February. Now, what I can is there any suggestions? I already built the fence because I need to move in. I got a young family to, so can I do something about it, or what if they say we don't going to pay you half anyway? So what my chances?
Slim. Your chances are not. What the Fencing Act talks about, Chip, is the need to contribute to the cost of a fence. But if there's already a fence, what's the need to contribute?
Well, now I build a new fence. So
No, that's my point. No. You need to think of it in terms of a need at the time you make the ask.
Yeah, okay.
So I need a fence. I need a fence today and I want you to pay half. Is not the same as I have already built a fence and I want you to pay half.
Okay. So it's up to them.
All right, so your chances of recovery are more related to their good graces than the law.
Good luck. Well, there is no good luck, Shiv. It sounds like it's bad luck for you. That's an interesting point, David. Ask before, get it sorted before you actually...
Oh, absolutely. Absolutely.
Before you go and do
Even if it's delayed payment, get a deal. Yep.
Peter in Ballarat. Hi, Peter.
Hi, how you going?
Good, thanks. Another fencing issue.
Another fencing issue, I'm sorry. We've got a colour-bond fence between us and the neighbours. And the boards at the bottom of the fence are rotting away just in two of the panel spots where the neighbours have a garden. Now, so we went and approached them because our property sits a little bit lower. It's at the bottom of the boards, and
bottom of the hill.
Sits a little bit higher. Yep, just a slight downhill. But so I went and approached them to replace the boards, thinking this is a pretty simple job. The steel panels just slide out and the new boards go in. But in the end, they don't want to muck around with their side of the fence because they've built an elaborate garden in there, and they've asked us to fix it from our side and put a retaining wall basically along our sort of side of the fence now, which is not appropriate from our point of view. But so I just wonder what do I do? Like I'm thinking at the minute I'm just leave it and their garden will fall into our place. And
how deep are your pockets, Peter?
So they're two boards. They're two boards.
No. I'm not asking you how deep the plinth is.
How deep am I?
I'm really asking you how much you're prepared to spend. Now they are logically. Then fix it yourself.
Yeah.
But put
it's
in
going to
75.
impact them if I pull it out.
If
I pull the fence out, the stuff that they've built on the other side will get impacted in some way. So
where does that leave him, David?
Well, we can talk about what your rights are, Peter. They are obliged to keep their dirt on their side of the fence. If the plinths have gone as a result of their failure to keep their plantings free of the plinth, then that's their problem and they have an obligation to pay for it. Right?
Yeah.
But I don't know, that doesn't get you, from the practical point of view, the answer would be to change the plinth boards.
Yeah.
Even if it was done from your side, it would be cheaper than anything else.
Yeah.
So
but
yes,
to
you
change
could
the plinth
go.
boards, you have to pull out the whole fence panel, and that's where it will impact what they've built on the other side. So
does that matter, David? I mean,
and you're not. Well, the problem, of course, Ali, is that Peter's not actually allowed to do it, absent the agreement of the neighbour or the magistrate's court. See, there's self-help is not. Often we talk about self-help as being the practical solution to most issues, but from Peter's point of view, there's actually a provision in the Fences Act which says, "Thou shalt not take on fencing work without the consent of the neighbour or a court order."
Oh, so that's where Peter has to go.
So that's where Peter's although, while I'm not encouraging you to break the law, one of the issues that you need to think about is what's the price of getting it wrong?
Oh, Peter, look, good luck with that. Gosh, these fences is a very complicated issue. Let's move away from fences for a tick.
Let's not do fences for a second.
Yeah, exactly. Ryan in Northcote. Hi, Ryan.
Hi, how you going?
Good, thanks.
I've got an apartment that I've just bought. It's in a body corporate situation, and the courtyard is on title, but I don't have access to the courtyard, and I want to knock, an opening up to that courtyard. The body corporate has advised me informally that the exterior of the building is common property, and that technically.
So you want to create. You want to. It really depends on what your plan says, Ryan.
Yep.
But the general proposition is that the building belongs to the owner's corporation.
Right.
Not the owner of the unit. Now, depending upon the age of the development and who did the plan and when it was done, there might be different principles. But in most modern developments, the structure belongs to the owner's corporation.
So this is an older building. It's 1970s. So
you still
it is
need.
An older building.
Yes, but I can't tell you what the plan says. The general proposition is that. So if let's say that there's 3 or 4 units all in a row, the backyard, the boundary between the unit and the backyard is probably the responsibility of the owner, but the front wall is probably owned by the owner's corporation. So you can't punch a hole in an owner's corporation wall without the consent of the owner of the wall.
Yep. Okay. All right. Well, thank you.
All right. So I would be sitting down with your lawyer or conveyancer from the time of purchase and say, show me what I can and can't do at this particular point.
Good luck, Ryan. I'm going to quickly squeeze in one more. Ian in Dingley Village. Hi, Ian.
Hello. I'm the executor of a will, and we've reached the point of distribution of monies, and I'm being asked by my solicitor to sign an indemnity, and that I should seek independent legal, financial and taxation advice. I'm wondering what are the issues and what are the risks if I don't seek that independent advice.
I'm sorry. This is your lawyer asking for an indemnity to protect who?
To protect my lawyer.
Oh, wow.
In accordance with the Administration and Probate Act, by signing this agreement, I acknowledge that a distribution is made within 6 months of the grant. I will be personally liable for debts and claims. And further, I
Okay, that's a different question.
Yeah,
right?
well, they were all in the one letter.
I understand that. So here's the deal, right?
Yep.
That the Administration and Probate Act, there is a provision, I think it's Section 91, subsection
99A3.
Yeah, so there's a provision that says you can make a distribution within 6 months of the date. There's a provision in the Trustee Act under Section 33 that says you can make application for advertisements for people who want to make a claim against the estate, and at the end of 60 days, you're only required to take into account those claims of which you have notice. You can ignore everything else. Yes. So if there's a pharmacy bill or an estate aid or a bill for a newspaper, then that you've never been told about, you don't have to worry about them anymore. There's then a provision under the Administration and Probate Act that says if you want to make a claim against the estate and you're eligible, you've got to make it within 6 months.
Yes.
And if you don't, so where we often get to, I'm in the middle of one at the moment, is where somebody wants a distribution from the estate after the 60 days but before the 6 months. What you then do is you then get written advice from each of the beneficiaries consenting to the distributions you're proposing to make.
Yes.
All right, and if you don't do that, then the answer is you will be liable.
Well, in this case, I'm outside the 6 months, so it doesn't matter. But the other clause here is I confirm that that I've been advised to seek independent legal and taxation and financial advice prior to authorising the distribution.
I'm embarrassed by your lawyer on what you're telling me. The lawyers, they're supposed to be advising and assisting you.
It shouldn't be.
It may well be that you're coming along and wanting to do something that your lawyer has advised against. In which case, what he or she is asking for, I understand, but that makes no sense to me.
Well,
my view is go off and get the advice, and it would be a charge on the estate.
Ian, good luck with that one. David, lovely to have you back. Lots of people just texting to say lovely to have you back.
Thank you very much.
So go well, and we'll talk. Well, I won't, but Virginia will talk to you next week.